Alvaron?
Here.
Mr. DeCosta?
Present.
Ms. Gomez?
Here.
Ms. Coffinger?
Here.
Mr. Lombardi?
Here.
Mr. Luno?
Here.
The flag salute.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
In accordance with the provisions of the New Jersey Open Public Meetings Law, the New Milford Board of Education has caused notice of this meeting to be published by having the date, time, and place thereof in the record, the New Milford Public Library, the New Milford Borough Hall, and the main offices of all New Milford Public Schools. The board announces that under its long-standing policy, it will not discuss in public any comments made by members of the public concerning individual staff members. At this time, please be advised that all cell phones and electronic devices are to be turned off. Meetings of the board are open to the public, and all members of the community should feel free to participate. Before coming to the board, the chain of command should be followed. There are two portions of the meeting reserved for comments from the public. The first at the beginning of the meeting for agenda items only, and the second at the end of the meeting for other items. Issues raised by the public may or may not be responded to by the board, but all comments will be considered. The board requests that all members of the public be mindful of the rights of other individuals when speaking. Due to confidentiality and legal rights afforded by the state of New Jersey, members of the public are asked not to speak negatively or in a derogatory manner about any employee of the board or any student. The results of the annual school district election held on November 7th. There are 3 seats for a 3-year term: Ms. Nicole Dunn, Ms. Paige Ryan, and Mr. Anthony Albro. So would you, the 3 of you, please join me?
We're back there.
Or where would you like? No. Aren't you comfortable?
Yeah.
Thanks for putting my name on.
I know.
No confusion. You want to say swear?
I'll say swear. Makes it easier for the.
Then you're all. I, please state your name, do solemnly swear that I will support the Constitution of the United States and the Constitution of the State of New Jersey.
I, Paige Ryan, do solemnly swear that I will support the Constitution of the United States and the Constitution of the State of New Jersey.
And that I will bear true faith and allegiance to the same and to the governments established in the United States and this state under the authority of the people, so help me God.
And that I will bear true faith and allegiance to the same and to the governments established in the United States and this state under the authority of the people, so help me God.
I, please state your own names, do solemnly swear that I possess the qualifications prescribed by law for the office of member of Board of Education, and that I will faithfully, impartially, and justly perform all the duties of that office according to the best of my ability, so help me God.
I, Paige Ryan, do solemnly swear that I possess the qualifications prescribed by law for the office of member of the Board of Education, and that I will faithfully, impartially, and justly perform all the duties of that office according to the best of my ability, so help me God.
Furthermore, I affirm and declare that I am not disqualified as a voter pursuant to RS 19-4-1, so help me God.
Furthermore, I affirm and declare that I am not disqualified as a voter pursuant to RS 19-4-1, so help me God.
Congratulations.
Thank you.
Can I take a picture? Wait, when you take a picture. It's purple.
Thank you.
I just punched it. I saw that. Okay, no. The paper? Wait, don't do purple.
That's how you know what's going on.
That's how you know it's me.
I would like to stand, yeah.
We want a picture.
Great.
I need your signed one.
Do you want me to?
I'm a Colby.
You don't want to be on the picture. It's Colby. Great.
Thank you.
Thank you.
You may now take your seats. Now the roll call of the new board. Mr. Albro?
Present.
Ms. Calderon?
Here.
Mr. DeCosta?
Present.
Ms. Dunn?
Present.
Ms. Gomez?
Here.
Ms. Coffinger?
Here.
Mr. Lombardi?
Here.
Mr. Luna?
Yes.
Ms. Ryan?
Here.
Now we have a presentation by our board attorney, Vic Lapira, on each item.
Who has the clicker?
Who has the clicker?
I believe it's right here.
Okay, cool.
You can do it right from there. You don't need to go.
Yeah, this is fine. Proceed. Okay, thank you very much. Can everybody in the back hear me? Good? Great. So I get to give this presentation to a number of school districts and to parents who reside in those school districts. I've been presenting them on HIB probably since the introduction of the Anti-Bullying Bill of Rights Act about 11 or 12 years ago. And so what we're going to do tonight is just do an overview, the definition of HIB, what administrators' duties are, what the investigations process is like, the consequences in the appeal process, and then kind of overview of some HIB decisions, so this way you know the way that the courts have interpreted the Anti-Bullying Bill of Rights Act. So the first thing that we kind of talk about is the definition of HIB, but also the purpose. The reason why the Anti-Bullying Bill of Rights Act was enacted about 12, 13 years ago was in response to a number of issues throughout the state, one of which had to do with a student in Toms River who was bullied for years in the elementary and middle schools, then went to the high school. They didn't transfer the records up. The high school didn't even know that this kid was bullied. And so that school district was dealing with it on a very piecemeal basis, but never did anything to really address the bullying, and ultimately was found liable. The student went to another private school. They had to pay for that. They had to pay damages to the parents, so forth and so on. Because it was doing things in a very different way, it was handling them on a piecemeal basis, but wasn't doing enough. So the reason the Anti-Bullying Bill of Rights Act was passed was to make sure that all school districts in New Jersey have a model and have a template that they're going to follow in terms of what they're doing, basically adopting all of the best practices. So the purpose is to make sure that we are trying to, as much as we can, change the environment. We're never going to eliminate all bullying so long as human beings exist, but we can do whatever we can do to try to minimize that and to serve as a model for students that they need to treat other students with civility and respect. So the goal is to kind of change the outlook, which I think over the course of 12, 13 years has happened. So now we look at the statutory definition of HIB. This is, I think, like 100 or 102 words. That's how you know a lawyer wrote it. It's a very simple concept in a way, but it's very detailed, and what I usually try to do is break all of that down into little chunks so it's a little bit easier to follow. So when we look at the criteria for HIB, there's a few things that have to happen. Number one, there has to be an act, and we'll get into the details of each one of these things later. The location has to be on school property or on a school bus or a school-sponsored event or function. Could be off school grounds, but that's limited. We'll talk about that. The act has to be some kind of verbal act or physical act, or it could be a written or electronic communication. And then it has to be reasonably perceived as being motivated by an actual or perceived characteristic of the victim or some other distinguishing characteristic of the victim. We'll get more into those details. And it has to substantially disrupt or interfere either with the orderly operation of the school or the rights of other students. That's a piece that I think often gets lost, especially in the beginning when we first had the Anti-Bullying Bill of Rights Act, but that has to happen as well. So all of those things have to be met. And one of the next three, which is that it has to have some type of effect, which is either a reasonable person knows that it would physically or emotionally harm a student, or does physically or emotionally harm a student, or damage a student's property, et cetera, or that it insults or demeans a student, almost always, but not always met, or it creates some type of hostile educational environment that interferes with the student's ability to learn. So one of those three things have to be met, but all of the prior prongs must be met. So in terms of the act, what are we talking about here? That's probably the easiest one, but verbal acts, physical acts, those are very obvious and apparent. Things that are a little bit more nebulous, but could be an act, involve spreading rumors, purposely excluding students from activities, breaking up friendships. I mean, those are all probably in some form of verbal or electronic communication, but those are things that could happen. They probably fall within the other categories as well. And then electronic communications, self-explanatory, but anything that uses an electronic device. Could be a telephone, could be email, could be social media messages, could be text messages, all of those things. Those can all qualify as an act. Now, the other piece that comes up here is what's the motivation? What is the reason why the student who is alleged to have committed an act of HIB did what he or she did? So the cases are pretty clear that it has to be reasonably perceived as being motivated by some distinguishing characteristic. It's not that it's actually motivated by, and there's a couple of reasons for that. Number one is, if you ask a student, well, why did you do this? Did you do it because of the student's race or religion or whatever? They're going to say no, right? And we can never know what's in their actual head. How did everybody else feel? Did everyone think, well, yeah, he clearly did that because of this student's race, based upon the things he said before he punched him, or whatever the case may be? How does a reasonable person look at that and say, well, do we think it was motivated by that kid's race or religion or what have you? If so, then yes. So the question is, is that reasonable? When we look at the motivation, what is it motivated by? Oh, this came out a little bit weird in this, but so there's actual perceived characteristics. Those are all characteristics that are set forth in the New Jersey law against discrimination. Race, color, religion, ancestry, national origin, gender, sexual orientation, unfortunately the bottom got cut off, but gender identity or expression, or some mental, physical, or sensory disability. New Jersey's law against discrimination protects students against discrimination or harassment based upon those specific categories. That case involving Toms River was brought prior to the Anti-Bullying Bill of Rights Act under the New Jersey law against discrimination. What you don't see there is age, which is a deliberate omission that the Anti-Bullying Bill of Rights Act did. And why they did that, I can't really say, but it could be a scenario in which kids are being bullied because of age. I mean, theoretically, if you had a bunch of seniors who were bullying a bunch of freshmen because they were freshmen or something like that, yeah, that could qualify. But that would fall under some other distinguishing characteristic. Usually we look at that as something that makes that student distinct or different in some way. Could it be, hair color or piercings or things like that? Sure, like some kind of physical appearance, yes. Other things that it could be, but are a little bit harder to prove, grade level, it could be political beliefs. When I first started giving this presentation years ago, I would say that's kind of silly. Who's going to get bullied for being in like the Young Democrats Club or the Young Republicans Club? Now, maybe that's very possible. Social standing, hard to prove, but could be. Socioeconomic status, that could happen as well. What we have in the bottom there, probably not, is something that is comparative in nature, right? And the example that I typically give there is someone says, well, this bully is a lot bigger than the other student. Okay, but he's not bullying the student then necessarily because that student is small, right? If I said the biggest kid in the school was shaking this kid down for his lunch money, you would say, oh, well, maybe he's bullying him because the other kid is small. What if the kid who's being bullied is the second biggest kid in the school? You can't objectively say the kid's being bullied because he's small. He's the second biggest kid in the school. So it's not about comparative. It's about something that's relatively objective. That is the basis for the bullying. If there was a kid who was objectively, one of the shortest kids in the school, and they were saying things to that kid about, his height or whatever, yeah, well then that could certainly be, but not on a comparative level. When we talk about substantial disruption or interference, right, that's one of the components that has to be met. It's, again, the concept is that it's substantial, that if something happens that is either substantially disrupting this kid's rights to attend school or interfering with the orderly operation of the school. What do we look at when we look for those things? Did it affect the child's attendance? Did the child say, I don't want to come to school anymore, and stop coming to school for days? Does the child need to be moved to a different class? That could, and again, these are things that are not necessarily outcome determinative, but they can be factors in determining, yes, there was a substantial disruption. Does a child act differently? Do they have physical manifestations? Did it somehow disrupt the learning environment? Something that sets aside instruction for 5 to 10 minutes is not going to qualify. That's not a substantial disruption to the learning environment. If it kind of disrupts the entire school in several classes throughout the school during the whole day, yeah, that could be a substantial disruption to the orderly operation of the schools. So to give 2 examples, and this case here from Bridgewater Raritan was the first case that really, in 2014, now this was like 3 or 4 years after the law was passed, that really delved into this issue of substantial disruption and interference. This was a case where 8th grade student, 8th grade boy was infatuated with and harassing a 7th grade girl on the bus, propositioning her to engage in various sexual activities, asked her to strip over video chat, all these harassing things. So originally that board didn't necessarily find that it was HIB, if I recall correctly, but that was ultimately found, no, that was HIB. And why? Because this was the type of lewd, indecent, offensive conduct that, it clearly was being done based upon the kid's gender, so forth and so on. And the judge found that, and the commissioner agreed, that the student had the right to be secure and let alone. And that was interfering with this. And again, it wasn't, sometimes you have single incident cases, it could be a single incident, but this was not a single incident case, and that's what we usually look at as something that is more of a classic harassment, intimidation, or bullying. It happens over time, it happens frequently. The law is clear that it could be a single incident, but I think the standard is a little bit higher when it comes to that. Another example, this was a case in Franklin Lakes, also from 2014. It was a black student who other kids were yelling Kool-Aid at, and the victim was very upset by it. He left a sporting event early without giving any explanation. He didn't want to go to school, wasn't fully available for learning, and I think the student, as I recall, was biracial. His mother was black. He told his mom not to come to the school concert because of this bullying that was going on by the other kids. So that was an example of something that was substantially interfering with this kid's rights. And it interfered his ability to learn. That was what the facts brought out there. So again, we kind of talked about this a little bit earlier, but in terms of the effect, one of these things has to happen. So the first is a reasonable person should know that it will either physically or emotionally harm the student or damage the student's property or put the kid in fear of that. Well, those are pretty straightforward. That's often but not always met. Number 2, is it insulting or demeaning any student or a group of students? Almost always met, I will say. I think there might be a case in here where that technically wasn't met, but it could happen. And then 3, did the act create a hostile educational environment for the student by interfering with the student's education, in a significant way, or severely or pervasively harming the student? Sometimes met, but usually one of the first 2 is met, and that's kind of where those decisions are made. In terms of location, as we discussed, straightforward, easy, on school grounds, on a school bus, that's the same as school grounds, school-sponsored function, once again, the same. Off school grounds, a little bit harder. And the reason that's a little bit harder is because there is a statutory, or there's actually a statute and there's a regulation that talk about when you can discipline students for conduct that happens off school grounds. And that's when it's reasonably necessary for the student's physical or emotional safety, security, and well-being, or for other staff or school property, and when the conduct that is the subject of the consequence materially and substantially interferes with the requirements of the appropriate discipline in the operation of the school. So it has to be something significant, and it has to be tied into what's happening in the school. It has to have some type of nexus, to use another word. So outside of the context of HIB, but just to give you an example of what does count, what doesn't count, a student who's arrested for possession of controlled dangerous substances off school grounds, that's not going to be a basis for us to discipline. a kid in school. A kid who was dealing controlled dangerous substances off school grounds, yes, because we know that his clients, if you will, are probably going to be, his or her, are probably going to be in the school district, and it would materially and substantially interfere with discipline in the operation of the school if we didn't discipline a kid for that. So that's the type of, has to be pretty significant to discipline for off-school grounds conduct. All criteria need to be met. This is a weird case, but an interesting case. It was a student who got a haircut. He dyed his hair blonde. One of his classmates said, "Oh, you look like Donald Trump." And I guess he found that to be insulting. And they said that it was a hib. Okay, so there was an investigation. They said, well, it's not a hib because even though it satisfied most of the elements, we had a verbal act, it was perceived as being motivated by his hair color or whatever it was. They found that it was insulting or demeaning to the student, which is kind of an interesting conclusion, but whatever it was. But they said there was no evidence that the comment substantially disrupted or interfered with the kid's rights or the operation of the school. There was testimony that came out at the hearing before the commissioner that he had shaved his head and was reluctant to return to school, but there was no documentation to support that. So the commissioner said it's not in the HIB report, there was no documentation prior to this hearing about that, so they kicked it back and said, this is not a HIB. So every piece has to be met. Now, also important, and there are a couple of cases that deal with this, not every code of conduct violation is going to be a HIB. And that's an important distinction because there are certain circumstances where kids engage in inappropriate conduct, peer conflict, but it's not necessarily because of some type of distinguishing characteristic, right? And there are cases that deal with that. There was one case that dealt with a kid who was allegedly being called names, and there were verbal jabs because all of the homerooms had a contest to see who was going to get a pizza party, whoever had the best attendance. And this kid was out a lot, so the other kids were getting on his case for being out a lot. He felt it was a HIB, it was appealed. They said, well, the fact that his attendance was poor was not a distinguishing characteristic. It wasn't a HIB. It wasn't appropriate conduct by the other kids. They got disciplined for it, but it wasn't HIB. Also, this West Morris case, this to me is like the ultimate New Jersey case. There were two kids who were arguing about who was the better fencing team member or a better fencer, and one of the kids said it was HIB, and they said no, not every dispute is HIB, and the fact that one kid thought they were better than the other is not a distinguishing characteristic. So again, importantly, just because it's not HIB doesn't mean the other student gets away with it, right? And sometimes parents don't know that there's been discipline imposed on the other kids because, of course, we're bound by confidentiality rules. We can't tell you, what would happen to another kid, what kind of discipline they would receive. Just like if your student was, your child was involved in something and the other parents want to know, well, what did you do that? Well, we can't say. We never can. So that's one of the issues that comes up there. But, code of conduct violations, school districts will always handle those code of conduct violations, even if it's not a HIB. Now, in terms of administrators and what they have to do, there is a form available through the website. It's called the HIB 338 form. I don't know, the Department of Ed gave us that number. I have no idea what the significance is. But that's the form that's going to be used for not only school districts, staff, but also parent and guardians when they are making a written report to the principal. The principal does have the discretion to decide, which we'll talk about a little bit, whether or not to even conduct an investigation, depending upon the facts that are given in the beginning. But regardless of whether that discretion is exercised or not, you still have to fill out that form. It has to be kept on file at the school. It only goes into another kid's record if there is some discipline involved. And if parents are requesting a hearing and then they ask for the copy, then we share the redacted copy of the form that removes all the student information except for their child's information. The form was revised this summer. Now it has a timestamp box. It has a signature page. Families can report anonymously if they want to do that. There's a provision there that allows them to list witnesses. So you could put your own name as a witness. so that you can still contribute to the investigation, but you can make the report anonymously. If you are a parent or a student, staff members have to sign the form and fill out the form. And they have an obligation. If they see bullying, they have to report it. So, and there's some guidance about this preliminary determination that the principal can make. So, in terms of the preliminary determination, the principal is allowed to do that if, based upon the facts that come up right from the beginning, it's pretty clear it's not going to be a hit. And what is the best example of that? The example that I typically use is, someone says, hey, I want you to investigate, Johnny for this, for hit because he punched my, child in the face. Okay, well, what happened? Well, my child said that Johnny was a jerk and spit on him, and then this other kid punched my child in the face. Okay, anything else? No, that's it. Okay, well, that's a code of conduct violation. Like, Johnny's going to get in trouble. There's no question about it. You can't punch kids. But it's also not a hit. It wasn't based upon some kind of distinguishing characteristic. They had a dispute about, whatever, a social conflict. So that's one where the principal would say, I don't need to investigate this. We're going to discipline it and handle it the way it needs to be handled. Now, when that happens, that gets reported to the superintendent. Can the superintendent look at that and say, hey, you know what, I want you to do an investigation anyway? Yes, that can happen. And then when the superintendent gives her annual report to the board about HIB, there's also going to be a determination or a discussion about how many times principals made those determinations not to investigate. So it goes all into the reporting, and parents can appeal that. If there's a decision made not to investigate, that can be appealed. So the standard is basically, if all the facts that were reported to me as the principal are true, can it be a HIB? Let's assume all of those facts are true. Is it a HIB? If no, then you don't need to investigate. There could be other facts. There are times when you don't have all the information. That's when we typically investigate. But if it's pretty clear from the beginning that it's not going to be a HIB, then there's no need to go through that process. Again, we talked about this already. The superintendent could disagree, could send it back to the principal to do the investigation, and the parents can appeal that determination to the board. So those are two of the times when that preliminary determination could be overturned. In terms of reporting timelines, if someone witnesses an act of HIB, they're required, especially staff members, they're required to report it to the school principal verbally on the same day, and then in writing within 2 days. And we're going to use the HIB 338 form to do that. This applies to school employees. It applies to contracted service providers. Technically, it applies to volunteers who are in the schools as well. But whenever you witness or receive reliable information that a student has been subjected to an act of HIB, those are the timelines that have to be followed. So when we talk about investigations, consequences, appeals, so forth and so on, what happens? Well, when the principal determines that an investigation needs to happen, it gets sent to the anti-bullying specialist. And the principal could appoint other people to assist with that investigation as needed, but usually the anti-bullying specialist does it. If it's about a staff member and it's in the same unit as the anti-bullying specialist, in that case, typically it's done by an administrator and not by someone in the same union. But normally the anti-bullying specialist does all of these. Has to be completed within 10 school days from the day of the written report. So if it happens, the written report is filed 2 days later, within 10 school days, it has to be completed. If there's an issue, usually it can almost always be completed within 10 school days. There are some times when it's a little bit difficult. Perfect example, which happened, in the past couple of years. We go to investigate. As soon as we receive the report, it turns out that the kid who was the victim or who was the aggressor has COVID, is out of school for 2 weeks. Okay, that makes it more difficult, but, A, we have Zoom, so we can still do that. B, if there is an issue and there still needs to be additional investigation, you file the report and you can always amend the report. And that's what the statute says, so it has to be done within 10 days. Then it goes to the superintendent who reviews it. Once the investigation is done, it gets sent to the superintendent within 2 school days after it's completed. The superintendent can decide to do a number of things, to provide additional discipline, to provide intervention services like counseling. Superintendent could do training programs to reduce the number of instances of HIB that, maybe there's something specific to a grade or to a classroom or what have you, so forth and so on. So that's now the superintendent's purview once it gets to the superintendent. Next, it goes to the Board of Ed. So it gets reported to the board, and the board gets information about, what actions were taken. and details. After it gets reported to the board, then within 5 school days, the superintendent shares information with the parents, saying, well, this was the nature of the investigation, whether HIB was found or whether HIB was not found, and whether there was any discipline imposed or services provided to address that act of HIB. Can't get into the specifics of discipline, but whether discipline was imposed, you can talk about that. And if parents make a request, they can get copies of those investigation materials. Again, it has to be redacted. But that happens, you know, within the first report. So then after that, if parents want, they can request a hearing. That hearing can be requested within 60 calendar days. The board has to have it within 10 working days, I believe it is, or school days of the request. It's done in executive session. It's not done in public to protect the privacy rights of everybody involved. The board can hear from the anti-bullying specialist about recommendations, but there's not a requirement to do that. And then after that is done, at the next board meeting following receipt of the investigation results or after the hearing, the board issues a written decision to affirm, reject, or modify the HIB determination. Now, I think this may come up later, but I'll bring it up now. It's not an adversarial process. I mean, there are cases that talk about that. There's no right to cross-examination. There's no right to hearing testimony. It's an opportunity for the parents to present their explanation as to why they think the decision that was reached was incorrect and why it should be different. So, you know, that's typically the way that is done. If there's dissatisfaction after the parents get the written decision from the board, they could appeal to the Commissioner of Education within 90 days of issuance of the board's decision. Or if it's specifically about, which we do not see this a lot, candidly. I mean, you know, the last 12, 13 years, I don't know if I've seen this once or twice. But you can file a complaint with the Division on Civil Rights within 180 days if there's an allegation that this somehow violated the law against discrimination. So if a kid was being bullied because of their race or their religion or something, or gender identity or expression, yeah, those are bases for going to the Division on Civil Rights. I mean, we represent about 50 or 60 school districts at any given time. You know, I candidly cannot remember that happening since the passage of the law. Prior to the Anti-Bullying Bill of Rights Act, that's where you went. In terms of sharing information with parents, you know, you have to get contacted by the principal about the incident, the day of the incident, to talk about, you know, what's going on a high level. You're not going to get a lot of information because one of the things that we don't want to do is kind of give too much information so that this way, you know, the kid goes home, parents say, what happened in school today? Did you do this? Did you do? And now the kid starts, before we have an opportunity to question the kid, starts getting anxious. Sometimes you might be surprised that kids don't tell their parents the truth about what happened, but that does happen sometimes. And you know, there's a whole host of issues. So you get high level of information, you get additional details later as the investigation goes on. Again, once it's complete, and we talked about this already, this is a little bit duplicative, but the parents get information about the nature of the investigation, what the result was, whether there was discipline, and then if they want copies of the materials, they can ask for those, but they have to be redacted. So in terms of consequences, this is relatively new. I think about 2-3 years ago, the Department of Ed specified that for the first and second act of HIB, if a student is found to have violated the Anti-Bullying Bill of Rights Act, the district may provide counseling or behavior intervention services or discipline or both. That's all, you know, fair game as determined by the principal. If there's a third act, the principal has to develop an individual student intervention plan, which has to be approved by the superintendent, and there can be a number of remedial actions that happen there. You know, basically, to put it in layman's terms, we have a kid who doesn't get it yet, and now we're going to have this individual plan so that they do get it. And one of the things that you can do is you can require the student, accompanied by his or her parent or guardian, to complete a class or training program to reduce HIB behavior. And the investigation reports, if there's a finding, do go into the kid's student records. I know there's a lot of parents that get anxious about it. This is not going to be the reason your kid doesn't get into Harvard. There may be other reasons why your kid doesn't get into Harvard, but this is not going to be the reason. And also, like, colleges only care about discipline at the secondary level anyway. So if you're talking about something that happened in 4th grade or 7th grade, that's never going to make its way up to any colleges or post-secondary institutions. In terms of consulting with law enforcement, that happens pretty rarely, but we are required to do that when the behavior might constitute a violation of the New Jersey Code of Criminal Justice. It doesn't happen a lot, but on the occasion that does happen, we have to make that referral. There is a possibility for, when it comes to cyber harassment, there could be scenarios in which parents could be fined. This is kind of a little bit, it's related to HIB, but it's nothing that we get involved in. But if your kid engages in certain conduct and you go to municipal court and the municipal court says, hey, you willfully or wantonly disregard the exercise of supervision and control over your child and allow them to do this, you could be fined up to $100 for the first offense and $500 for each subsequent offense. How likely that is, I don't know, but it could happen. And then finally, we'll just kind of review a couple of decisions where you're going to see a fair amount of poor behavior here. I apologize for what you're about to hear, but so number one, this is an important thing. The credibility of the witnesses is important, and we always tell the anti-bullying specialists always focus on that, make sure that that's clear. There was a scenario in which a kid airdropped a picture of another kid who was, I don't know, flexing for the camera, and I guess he thought this was funny, and sent it to all these kids in the cafeteria. So the kid whose picture was being distributed was really upset and said, oh, I think this is a HIB. So they were doing the investigation. They were like, well, why did you do this? Why did you share this picture? And he said, well, he called me a fat N-word during cooking class. That's why I did it. And so they said, oh, I think we're going to open up another HIB investigation. And this one's going to be about the kid who filed it. So after doing the investigation, first he said, I didn't say it. Then he said, I've said it in the past, but not this time. And then he eventually kind of admitted to it. And there were a lot of arguments that were being made here. The mom said that the confession was coerced out of him, so forth and so on. But the administrative law judge reviewed it and said, look, the anti-bullying specialist judged the credibility of the witnesses. She found the other people who said that he said it were credible. She didn't rely specifically on his confession, even though she could have, but she also relied upon other kids' testimony. And so ultimately it was upheld, right? I mean, the standard for overturning a HIB decision is whether or not the board acted arbitrarily, capriciously, or unreasonably in making the determination. They're not typically going to go in and judge the credibility determinations made by the people who did the investigation. Actual motivation and intent is not required. Again, it's hard to prove. So in this case, where a kid made a statement to one of her peers that she hates black people, that was reported to the victim. Her defense was an unusual defense. It was that, well, I wasn't trying to insult her, but I don't like the aftercare personnel who yelled at me and who happened to be black. Kind of a weird defense, I wouldn't use that. And it wasn't successful for her. They said it was HIB, it was motivated by race. The fact that the kid said it wasn't motivated by race was immaterial. Did everybody else think it was motivated by race? Yeah, they did. The victim didn't want to go to school, felt unsafe at recess and lunch, had all of these issues that made it seem like there was or that confirmed that there was a substantial interference or disruption. So that was ultimately the finding. The commissioner affirmed it and said, look, it's not actual intent because you're never going to know actual intent, but how did everybody perceive it? How is it reasonably perceived? This was reasonably perceived as being motivated by that student's race. We kind of talked about this one already. This is the one where the kid was, the kid's attendance was poor, and that's why they didn't get to go, they didn't get the pizza party or whatever it is. There's some other miscellaneous comments that were back and forth, unkind words, but there was no targeting because of the characteristic. They weren't making fun of him or doing whatever they were doing because of a specific distinguishing characteristic that this kid said. And I think it was important what the administrative law judge and the commissioner basically said here, which was that the mom was looking to protect her child from what she believed was bullying, totally fine, but not all disputes between students are subject to the HIB statute. Sometimes there's just peer conflict and kids that are not being nice to each other. And that doesn't mean that they don't get disciplined, as we've said, but it may not be a HIB. In terms of procedural deficiencies, this is really more for the, I guess the school district, but I guess as far as parents are concerned, just know this, that sometimes, notwithstanding the best intentions, sometimes school districts forget to do one step or another. So in this case, we had a transgender male sophomore who was using the stall by the boys' bathroom. People made comments about it, you know, saying, oh, girls shouldn't be allowed to use the boys' bathroom. There was, the kid was upset. There were issues. There were some procedural deficiencies here with this particular district. When they did furnish the investigation report, it didn't indicate whether or not the superintendent ever reported it to the board. The notice following the investigation was very vague and didn't maybe comply with the statute. The written notice just said that the HIP findings would be affirmed. It didn't say that they might be, you know, modified or potentially reversed. So it wasn't a great look for that particular district, but that didn't amount to a violation of due process, right? I mean, the student was given an opportunity to have a hearing. The student was allowed to provide testimony in his favor, was represented by counsel, so that was fine. Interestingly enough, the parent raised other procedural issues, but those were just dismissed. The parent said, well, you didn't interview the victim. Well, in that case, they didn't need to interview the victim. The statute doesn't require it. All of the other ancillary information corroborated what the victim had reported on the form, and the parents made a discovery request or whatever it was, and there was information that they were looking for. They wanted it to be more like a trial. They specifically said HIP procedures are not meant to mirror trial-like adversarial proceedings. So that case and a number of other cases kind of confirmed that if the parents want to appeal it, they get to have an appearance before the board. In terms of things that might constitute HIP or don't constitute HIP, weight and appearance, I mean, absolutely, it's going to be a distinguishing characteristic. This kid said to this other kid, your shoes are as big as sailboats. I don't know, that's kind of a weird thing to say, but the impact was significant because this kid was taking medication for some disability, and that medication caused the kid to gain weight. And after the bullying, the kid stopped taking the medication because he wanted to lose weight. So that's a pretty substantial interference with that kid's rights, and it's a substantial effect. He didn't want to go to school because he was afraid they were going to keep making fun of him. So ultimately, it was found to be HIP. One of the defenses that sometimes kids do is they say, well, you know, he was saying things to me and it was just mutual trash talk. You know what, maybe the other kid was guilty of a HIP too. It doesn't mean that you weren't. You know, if a kid says something nasty to you, it doesn't allow you to go and, you know, commit a HIP against him. And the claim that, well, I was just joking, that defense never works, and it didn't work here either. So that's an important one there. In contrast here, this was just a conflict. There was a student who had stolen this other kid's Chromebook several times and then turned it in, saying she found it. She was messing with this other kid. He figured it out. He grabbed her arm and wouldn't let her go. It was, you know, it was inappropriate. She didn't come to school for 3 days. She was afraid. She was uncomfortable. This kid made her really upset. Okay, that's fine. That kid deserves discipline. You can't just grab people and threaten them, even if they were doing things that were inappropriate. But this was just conflict between students. There was no actual perceived characteristic. He wasn't doing it because she was a female. He wasn't doing it because of her race or her religion. So, and in that case, the school did also implement like a no contact order. I mean, they took various actions to make sure that that the matter had been addressed. Again, code of conduct violation, not a HIP. In this particular case, another kind of a strange one, but it was racially motivated. There were a number of things that this one kid said that was constantly bringing up the fact that the victim was black and making a number of references to it. The victim was upset, tried to play it off and said, oh, it wasn't that bad, but there was one class where she had to be removed from her class because she was so upset and she couldn't focus on the class. And so, did she continue to go to school? Yes. Did her grades suffer? No. But still, you know, like having to be removed from a class was sufficient enough for the purposes of the HIP statute. Once again, the other defense was, well, she used to call me a cracker or whatever. That doesn't matter. That's not going to be a successful defense. You know, that's another example. When there is a substantial disruption, it could be something, I don't want to say as minor as, but it could be something that where a student just can't get it together to go to the next class, and that might in and of itself be enough of a substantial disruption or a substantial interference to that kid's rights. And then I think this might be the last or second to last case. There's a few more, but one was, so just bad behavior, but bad behavior targeting a kid who had a known nut allergy, and the kid was the kid was the bully, or was offering the kid a cashew, and the kid was like, no, don't touch me with that cashew, and then started touching his lunchbox and started touching his water bottle without washing his hands after he'd just been handling these tree nuts. So that wasn't appropriate. Everyone believed it was motivated by the kid's allergy. Student's defense was, oh yeah, I knew he was allergic to peanuts, but I forgot in the moment. Nobody believed that, and nobody will believe that. So now, interestingly enough, the administrative law judge said, well, this is not a pattern, it was just a one-time event, and that seems like a severe, that seems like an extreme thing. I'm not going to find that it's a HIB, and the commissioner said, no, even a single event could be a HIB. Not always, but it could be a HIB. But in this particular case, it placed the victim in fear of physical harm. And so, yeah, it was found to be a HIB. Again, not every HIB results in significant disciplinary consequences, but statutorily, it was a HIB. Kids being inappropriate in school, a text message sending a picture of Stewie Griffin from Family Guy, and then a picture of the victim next to it saying, hey, what do you call someone with a big head? And posting something on TikTok, and just, these are almost, by the way, these are almost all middle school students. That's where 90% of this stuff happens. So, inappropriate. It was targeting this kid based upon her physical appearance. She was upset. She missed several days of school. That was a significant impact. So that can happen. And in this particular case, even though the parents appealed it, there wasn't even a hearing. It was just done on summary decision on the papers because ultimately they never really argued or articulated why the board's decision was arbitrary, capricious, or unreasonable. And the commissioner said, well, that's that. If you don't argue that, you're never going to prevail. The last two cases here, or the last case here, this one was not a HIB because there was no distinguishing characteristic. The kid who said it was a HIB so there was a situation where a student pushed a peer and called him a racist during kickball practice when he, the victim, told the kid who was the alleged bully that he was in the wrong line. And then the parent reported this and said, 3 days after the incident, the peer had commented on the victim's size, calling him small. Well, the conduct in the kickball line was not based upon a distinguishing characteristic. It was just a dispute between students. The fact that 3 days later there was this comment about the kid being small didn't tie it in, and the anti-bullying specialist also said the kid is average height. He's not big or tall, he's not small. So there just wasn't anything there to tie into him. Bad behavior by the kid, sure. You're not supposed to push kids on the kickball line, but was it a HIB? No, not in this case. So that's the part that, when we kind of navigate this law, and we've been doing this for now 12, 13 years, there's a lot of cases that involved bad behavior on the part of students that almost always is going to, I would say, always results in discipline. Parents might not know what the discipline is, but it does result in discipline or the appropriate disciplinary consequences. And not every incident is a HIB. However, there are cases where there are HIBs. We have seen that. And when that happens, then the reporting gets done. Parents don't like the decision, whether it's the parents of the victim or the offender, they can always appeal it. But in the end, the important thing is that these are often dealt with, on the very first day, because usually there's an obvious code of conduct violation right from the beginning. And that's typically where the discipline comes in. Oftentimes, whether or not it constitutes HIB or not is kind of like I don't want to say it's an ancillary decision, but it's additional information. That may result, if we see something happening that's part of a pattern, if we see that there's a specific student that has committed a number of acts of HIB, or if we see there's a specific student who's the victim from other kids, that may lead to other types of ways of addressing it, more than just disciplinary consequences or some type of educational consequences. It might be a training program, it might be an assembly, or things like that. But anyway, I'm sorry for being so long-winded. I tried to do it as fast as possible, but that is the overview on the Anti-Bullying Bill of Rights Act.
Thank you.
Thank you.
Are there any questions or comments from any board members?
One question. You mentioned the code of conduct. Once something is determined not to be HIB, what's the process for it to go through code of, is it already going through code of
Yeah,
conduct?
usually it
and
already
then
goes
they're
through
HIB?
it, right? So what typically happens is, let's say there's a student, there's a situation where there's a, I don't even say a fight, there's an assault, right? One kid hits another kid. We saw it happen, we have reports, we know we're gonna impose discipline for that. That's fine. There's also now an allegation that, well, the reason this happened is because, he said this about the kid's race or about the kid's religion, whatever it was. And that was the motivating factor, and he said something the day before, like, I hate you, blank word, whatever. So that may then result in this separate HIB investigation as to whether or not it also constituted HIB. There could be additional discipline as a result. But I would say 99% of the time, the discipline will already be imposed for the code of conduct violation because we already know there was a violation of the code of conduct. It might also be a HIB in addition to that. That's typically what happens.
And then, so while the investigation for HIB is going on, there is something that's already been in place to reflect the code of conduct
Yeah.
violation.
Yeah, almost
So
all the
that's-
time. I mean, there may be other circumstances too where we're not sure if something happened, so the investigation needs to take place. But even during that point in time, we might also offer counseling services. We might need to do the investigation over the course of days to find out whether or not this actually happened. So there might not be discipline in the beginning, but it could be at the conclusion. We might say, all right, well, we determined this happened, now we're going to impose discipline. But my experience, over the last, whatever it is, 12, 13 years since we've been doing this, is that 95, 99% of the time, we know right away there's a code of conduct violation. It's just a question of, is it also a HIB?
This is like more of a procedural thing. So earlier in the presentation, it said that if it was appealed to the board has 10 days to hear that.
We have to offer the hearing within 10 working days, I think. I think it says 10 working or 10 school days. It's not calendar days. They confirm that.
So in the event that there is a board meeting that isn't scheduled for another 20 days, does the district have to hold a special meeting to accommodate that? Or, like, is it statute?
That's a good question. So candidly,
Or can they both parties agree that, yes, they'll do it the next meeting, et cetera?
that's what happens 99% of the time.
Okay.
We say to the parents, all right, I don't know if we're going to be able to get a special meeting. We do have a meeting 13 days after. Is that okay? My experience has been, like,
So what's
never
the
had a parent really complain about that.
What's the consequence to the district if they don't meet that? So, hypothetical situation. Parent says, we want to invoke our right to have a hearing in 10 days.
Right.
And the superintendent gets back to the parent and says, listen, we can't get a quorum together in the next 10
right,
days.
right.
We just can't do it, the earliest we can do it is this. What is the repercussions?
So what would probably happen is, because I've seen this happen in some of these cases, right, where there's a procedural violation, it usually will not be a significant issue so long as the party eventually gets that due process.
Okay.
There was a case where, we talk about one case, but there's been other cases where districts, for whatever reason, somehow bungled, let's say, the timelines or whatever it is, or they didn't do something right, but they ultimately got it right in the end. And so, what typically happens is there's a decision by, if it gets appealed, there's a decision by an administrative law judge or the commissioner saying the district did it wrong. That's never good. But the district made the right decision in the end, and they were right. It wasn't a HIB, or it was a HIB. So yeah, we always try to do it. To the maximum extent possible. We want to comply with the statute in terms of the 10 days. Can parents agree to do it outside the 10 days? Absolutely. Happens all the time. Because parents can't always come to every board meeting that we might have either. So, and they have up to 60 days to make the request. So sometimes they might make the request well after the HIB's already been decided and everything else. Yeah, usually there's not, the reason it's not typically so time sensitive is because usually whatever services or programs are going to be, put together, or whatever discipline's going to be imposed has already been done, right? It's typically a determination of, was the district's determination right or wrong? It's not, we're waiting to have this hearing for the district to now do something about it, right? Usually something's already been done. 99% of the time is what happens. So that's why it's a little bit less time sensitive. But yeah, we always try to do it within 10 days, and that's what the law says. Absent agreement, we have to do it then.
Can you explain why districts are required to report out on HIVs as opposed to code of conduct violations?
It's a great question, and I would say the answer to that is this. Because not only are districts not required to report, well, we do report out annually the violence and vandalism report, so there is some information about that. But, you know, like if a kid gets a 5 or a 7-day suspension for an assault, there's no right to appeal to the board. There's no, you know, like immediate right to appeal to the commissioner, all that stuff. That's specifically part of the Anti-Bullying Bill of Rights Act. And I think it was done that way because, frankly, you know, 15, 20 years ago and before, these weren't treated as seriously, you know, as fighting or other code of conduct violations. So it has had the unfortunate effect of kind of amping up all these decisions, right? You have the right, you get a letter saying you have the right to appeal, so forth and so on, which makes it seem to some degree much more consequential, especially if you're the parent and your child's the victim, and now you're like, oh my God, there's this scarlet 3 letters, HIV, on my kid's record, right? But it isn't necessarily more significant than, you know, someone who gets a 10-day or more suspension for dealing drugs or for an assault or whatever the case may be. So it's just kind of the vagaries of the legislature, right? They determined that we need to report out on the number of cases of HIV every year. And I think the other reason too is we compare those, and my guess is, I could be wrong about this, my guess is if we look at the numbers that existed 10, 12 years ago, and we look at the numbers now, they probably have gone down. And the reason for that is because kids are much more aware, right? Like, you know, you might have kids who say, oh, you know, Johnny was engaging in a hib against Sarah or whatever it is. You know, like 15 years ago, they never would have said that. And, you know, like, I mean, they might have mentioned that they thought someone was bullying, but, you know, like they didn't know the idea of like being an upstander instead of a bystander, any of those things. All those hib training programs that we have are designed to change the climate. And to some degree, by having this procedure and by having it be like kind of so rigorous, and having all of these, you know, bureaucratic requirements, I think it makes district focus on HIB a lot, make sure that we're giving those kids those training programs, and the whole idea is by calling this much attention to it, it's going to hopefully eradicate the problem. Eradicate might be a little bit Pollyanna, but it should minimize it, and it should reduce it. It's never going to take it away as long as we have human beings who come to schools.
I just want to interrupt and say, apologize. I have another voluntary commitment to attend to,
Okay.
so please forgive me.
Okay, I have a couple of questions. Just something based on what you said in the presentation about the perceived by the victim and or witnesses, right? Is it and or and?
No, it's and/or. Yeah, I mean, it has, and again, it has to be like reasonably perceived, right? Sometimes we've had cases where victims think, oh, they're doing it because of this, and nobody else sees
reasonable
that.
person,
Yeah,
right,
right,
yeah, okay.
exactly.
Which are hard to find when you have situations where your kid's being bullied.
Sometimes, yes.
So I guess my question is one, is there a way, it's hard to say. So you're saying it's not required to have a witness. Like, what if it's like a he said, she said? Like, what do you do in that situation?
Yeah, that happens a lot. So in those circumstances, what I tell the anti-bullying specialist is, look, you've got to do the best that you can do in judging those kids' credibility, right? There may be a situation where there were no witnesses. It was just the 2 kids. And we've got to do whatever we can to try to determine, well, who do I think is telling the truth? Sometimes it is just, you cannot make a decision. You know, there's just not enough facts to support, you know, the allegations. And in those cases, then we might find that there's not enough information there. In other cases, there might be reasons to believe, well, when I interviewed the victim, their story never changed, even though I asked different times. They were really upset, but they were clear about it. When I interviewed the offender, he told me one thing in the beginning, but then when I asked him later, he gave me another story, and then he wasn't making eye contact or whatever. There's a whole number of reasons why you might make a credibility determination. Those aren't necessarily, you know, they're not all going to always be appropriate or applicable, but yeah, that's what the anti-bullying specialists have to do.
So who has the burden, right? Like, who has a burden to prove or disprove something, or is there one in these cases? I know you talked about
right.
how things, it's not necessarily like a trial, but, I mean,
Yeah, there is
like,
some-
in the investigation, who has a
Right.
burden, like, where's the weight put as far as?
Yeah, I wouldn't
harassment?
say, so because it's not like an adversarial thing, there's not necessarily a burden, but it's just the investigator has to figure out, like, is it more likely than not that this happened? Is it more likely than not that if there are, I would say 99% of it, well, maybe 90% of the time, the facts are not really in dispute. Like, we almost always have the facts. Sometimes, like there's an altercation in the hallway, we've got it on the video, right? It's not typically that. It's almost always, what was the intention, what did a reasonable person believe was the motivation behind it, and was there a substantial impact, right? I mean, those are the pieces that are what the investigation has to get into. And that's also why sometimes the investigation takes time, right? Because we may not know what that substantial impact is, but if it turns out that it was reported to us on Monday, the kid doesn't come to school for 5 days because they're so upset about what happened, well, okay, then after the 10-day period, we determined, yeah, there was a substantial impact. But yeah, there's not specifically a burden, it's just that the anti-bullying specialist has to make that determination. Do I think that all of the elements were met here?
And this is, I don't know if this is for you, but probably more for Danielle. Is there a difference in the degrees of discipline for a code of conduct violation versus something that would qualify as a HIB? Like, are you getting punished in the same way potentially?
Generally, yes. You're being punished for whatever the behavior was. And therefore, there wouldn't necessarily be more discipline to follow up unless something additional evolved as part of the investigation that we didn't know on the onset. But like Vic said, usually this fight happens, there's a suspension, you're handling that at that point. Then other things come out and you may discipline those things at a later time if something comes out. But no, because it's a HIB, there is not, well, it was a HIB, so now you have to have this. In the event that a student is alleged to have been the aggressor in multiple HIBs, there are some supports that internally we will exercise, just because if somebody is being identified as an aggressor multiple times, then the discipline that we were giving maybe isn't enough, and we will follow up with other supports.
So for purposes of the difference between a code of conduct violation versus a HIB, can we generalize and say that all code of conduct violations have the potential to be a HIB, but not in the inverse? Like, when you're talking about a situation where someone could potentially be bullied or someone gets called a name, you're getting punished for the code of conduct, and then you're trying to figure out if there's like an escalator, right? Like something that makes it more punishable? Is there,
No,
or
not
are we, or
necessarily.
are they
Not necessarily
in
more
two different
punishable.
categories completely?
But you might have had a situation where there was a physical altercation, and then throughout the investigation, you realize that maybe there is a technology component, that there were text messages, that there were these other things that were happening, that you only addressed the altercation in the hallway thus far. We didn't address all of this. Oh, this needs to be reported to the police. That's a separate. So if something comes up that is unknown at that moment, but the code of conduct, whether this situation happened, is determined to meet the definition of HIB, or is a standalone fight in the hallway, you're still treating it like a fight in the hallway, discipline-wise. If other things come out during the investigation, you would address those other things separately. But they could come out and still not be a HIB, but you're still gonna address them as code of conduct violations.
Yeah, and it could be the services too, right?
And it could be services.
could be
Things could
that.
come out and you could say they need
Right.
services.
Like a fight in the hallway might be, okay, we're gonna discipline the kids, they're gonna get the consequences that are appropriate. If it turns out that the reason for the fight was because of some racial component or whatever it is, well, now we might be looking at, okay, well, how are we gonna address that? Not only with the students who are involved, but maybe if this is a common thing that's happening in this particular classroom or this grade level, maybe we've got to do an assembly or something like that. Those are things that we think about.
Makes sense.
So I just have one thing, and it kind of wraps up a lot of the other questions too, and it keeps coming to the same thing, so I'll just say this.
before HIV, right, there may have been incidents that occurred in the elementary or the middle or the high school, and, you know, it was called bullying. That's just, you know, people would say there's really bullying everywhere, but there wasn't an identifier. But there would be code of conduct, and there might be discipline or things that had to be taken care of. But the HIV, right, so now this is here, and this is a statute, and the state is telling us to report on it, and parents are getting notifications. And now, it's almost, it almost gets perceived as, if that says no, then that means my kid wasn't harassed, or that this thing didn't happen to my child. And I don't think that's what this is, and I just want to kind of like say definitively what I'm getting from what you're saying is that when something happens, whether it is harassment, whether it is physical, whether it is emotional, whatever it may be, there is an investigation into that. Regardless of whether it gets determined to be HIB, there is a consequence to those behaviors.
Right.
Whether it's separating students, or whether it's, you know, some services, or whether it's some discipline that's, you know, whatever it can be. It doesn't have to be a fight, it doesn't have to be anything. But one does not mean that something doesn't happen.
Correct.
But I think it's kind of raised it to that level, and I appreciate this presentation, because I think that for a lot of parents, especially who've only had children in school since this has been a law, might think that if you don't get HIB, that means nothing's happening. And that's, I think the two are different.
Right.
And I don't know what, I would bring this up as a district, I don't know what we can do other than we have this education here, which I think is great. But, you know, other ways, because we can't violate privacy. I wouldn't want my child's privacy violated, so, you know, I may not like it that I don't know.
Yeah.
I wouldn't like it. But I think that there's something there, and having this, I think, is great. And, you know, just listening to people, even though they're not saying they needed it, I think we need to continue to reach out in that way and let people know when this occurs. Just to be clear, this says this, but that does not mean, okay, now nobody thinks anything happened.
Right.
And I think that that's really important.
And the follow-up letter that goes to parents does say that,
Yeah,
you know, discipline and/or interventions, you know, will.
right, are occurring.
Right.
Just want, parents have to follow.
I tried to let her say everything she needed to say.
One other question. So, it doesn't have to be a protected class,
Correct.
right, for it to qualify as a
Right.
HIB.
Distinguishing
So it can be
characteristic.
distinguishing characteristics
Right.
such as color of their hair, you know, other, but I know we talked a little bit about comparatively, like calling someone small. Like if you call someone short, is that different? That's a physical characteristic as opposed to, so.
Yeah, but like, and again, it had to be something like, if you had someone who was like objectively shorter than everybody else, I think so. You know, I mean, you know, the tallest kid in school, everybody is short to him,
Yeah.
right? Her,
Okay.
whoever. So it's not based upon those comparisons.
Okay.
It's based upon something that is as objective as possible, right? I mean, if someone is saying they're making fun of someone because of their physical characteristics, I mean, that's pretty easy. Straightforward. But, you know, in cases where, you know, there are cases where there's just what I would call harassment, intimidation, and bullying with a lowercase h, lowercase I, lowercase b, right? Then that's not based upon a distinguishing characteristic, it's just kids being mean and inappropriate. And those are code of conduct violations, and we handle those that way. So, yeah.
Thank you.
All right.
Thank you. Open to the public for items on the agenda only. As outlined in New Milford Board of Education Bylaw 0167, each statement made by a participant shall be limited to 3 minutes. Can I have a motion, please?
Motion.
John, a second. Joe? Are there any questions from the public? There's none. Can I seek a motion to close to the public? Page, second. Stephanie? All in favor?
Aye.
Now, I would need a nomination for board president. Is there anyone willing to nominate? Nicole?
I would like to nominate Heather Gomez to continue as the board president.
Can I have a second, please? Paige. Cheryl, Ms. Calderon, sorry, roll call to. For
Oh, she forgot to say roll call. She should
Roll
have
call,
it.
yeah, sorry, Ms. Calderon,
Yes.
Mr. DeCosta,
Yes.
Ms. Dunn,
Yes.
Ms. Gomez,
Yes.
Ms. Coffinger,
Yes.
Mr. Lombardi,
Yes.
Mr. Luna,
Yes.
Ms. Ryan.
Yes.
Okay, here you go.
She's so happy to not have to do the rest of this meeting.
Yes.
Should pass it over quickly. Oh, okay, so I seek a motion to appoint a vice president. Need a motion? Stephanie Coffinger. Need a second? Paige Ryan.
Who are you?
You gotta nominate somebody.
Oh. I told you I messed this up every time we discussed it. Who do you want to nominate?
I'd like to nominate Nicole Dunn to continue as vice president.
Okay. Seconded by Paige. All in favor?
All right,
Aye.
roll call.
Roll call.
Sorry.
Stephanie, just take it over.
I'm here, I have to say it.
Ms. Calderon,
Yes.
Thank you.
Mr. DeCosta,
Yes.
Ms. Dunn,
Yes.
President Gomez,
Yes.
Ms. Coffinger,
Yes.
Mr. Lombardi,
Yes.
Mr. Luna,
Yes.
Ms. Ryan.
Yes.
That's official.
All in favor?
Aye.
We don't need a
Okay.
roll.
There we go.
That was a statement.
It's the roll call ones that trip her up.
Yes, it's still the roll call.
I'm sorry, whatever she
Not
says, I'm
on
gonna
here.
flow
Need a
with it.
motion for all of these.
Okay, I seek a motion for BA 23-24.39, point 40, point 41, point 42, point 43, point 44, point 45, point 46, point 47, point 48, point 49, point 50, point 51, and point 52. Need a second?
I have a question.
Oh, sure. We have the
Can you make a motion
Yeah.
first and then you can ask
So
the
that's the
question?
motion?
motion, second.
Second.
Paige Ryan.
My question, okay. So my question, and I discussed this kind of briefly with you, was I didn't get a chance to ask this. I sort of did, but I have to bring it up now. The conduct of public meetings, does that include the time limit of, public, time limit that they can speak? I don't know, like, what's definitive in whether or not that is captured by one of these procedures?
It is, because it's under the
The policy.
bylaws, which
Okay.
is,
So my thought on it, and I, again, spoke about this earlier, was, if you wanna keep it at the 3 minutes or whatever it is, right? If there's an ability for the board or some member to make a motion to ask for like an extension of like 2 minutes if you wanted to hear more information, if that's something we might wanna consider, given that, sometimes some people, they only get 3 minutes, sometimes if you want more, you want them to talk more, they could have a couple more, but again, that's just, something that I'm suggesting, not some, that's up to.
so I guess it has to be reviewed in the bylaw committee first.
Has to be reviewed.
And the only thing I would tell you is that what I see in different school districts is they often make a motion to extend the length of time. Like if you set aside 30 minutes for public comment, they often extend that time. But what I would say is if you extend it for one person, you're gonna have to extend it for everybody at that meeting, because what we can't do is that we extend it for one person, give them 5 minutes, and then someone comes up and they're saying things we don't like, and we say, you still have 3 minutes. We can't do that.
Yeah.
It's gotta be uniform, right?
Yeah, and that's
Yeah.
fine, I just, sometimes, there's barely anybody ever here. So it's not like we're having these long meetings where people are talking for 10 minutes, but if there are ones where there might be, a little bit more, just to be able to have that option, is just something that I would wanna think about.
I think that would definitely be reviewed.
Yeah, so the bylaw committee would have to meet and discuss it and decide, and then present to the board. Yeah.
So then how do I vote here?
So just saying that you
Just
agree
to
with
accept the
us
bylaws.
going on, and then
Okay.
we're gonna have to discuss it later
Okay,
as a bylaw.
And we'll do a follow-up about when the next meeting will be, so that you're aware of it.
okay.
Yeah, that's fine. Okay,
Was that an, all in favor?
So there was a nobody yet, you didn't do the
vote.
favor yet.
all in favor?
Aye.
Opposed? Okay, open to the public. I seek a motion as outlined in New Milford Board of Education Bylaw 0167. Each statement made by a participant shall be limited to 3 minutes. Need a second? Stephanie Coffinger, all in favor?
Aye.
Opposed? Any comments from the public? Please state your name and town.
Barbara Hutchison, Milford. Good evening, all. There's a statement made by the Board of Ed in every meeting. Before coming to the board, the chain of command should be followed. My stomach actually turns every time this is read into the record and makes my skin crawl hearing these words. Thinking of where teachers and parents, and most importantly students, go on this chain of command. Everyone's inner voice should say, what if the chain of command isn't working? That's most likely why folks are coming to the Board of Ed meeting. Case in point, why I'm here today speaking. Recently, and I know we've had the HIB in the presentation for the HIB, but there's obviously been several board meetings where there was a lot of concerning allegations made regarding improperly handling HIB investigations. I will tell you from my own personal experience, the district has been making procedural errors, which was highlighted during this presentation, okay, and left parents like myself in the dark. On October 27th, 2023, there was a 3384 filed on my daughter's behalf. The investigation was begun. On November 1st, we received a letter from the district. On November 14th, I spoke to the principal at Gibbs, who advised me that the HIB was unfounded and the district was working with the student and their family. I was advised that this would be presented to the Board of Ed and we would receive a letter as parents, essentially what the investigation found. As of December 6th, 2023, we didn't receive anything. I reached out directly to the superintendent following the chain of command. I received an email back from the superintendent advising me that she would apologize for us not receiving any letters and she'd get back to me. She would look into the incident. Approximately an hour later, I received a call from the principal at Gibbs, advising me she was unsure why we didn't receive the letter. Everything was sent to the superintendent's office. It needed to be signed off, and we would get those. I have nothing but positive things to say about the principal at Gibbs. The communication has been nothing but outstanding. Any emails, phone calls have all gone answered to myself and my husband. As of today, 50 days later, we still have not received notice from the district about the findings from the HIB investigation. Nothing has been, we didn't get whether the district found evidence of HIB as defined in the ABR, whether discipline was imposed, services provided to address the HIB, and it kind of makes me question, why haven't we received this? We've heard the presentation today, we were supposed to receive this. Is this to delay any possible appeal that myself and my husband could make? And of all people, trust me, I fully understand the chain of command. In my job, it is very important. However, a chain of command, especially in the school district, implies a strict hierarchy and archaic way of doing things, in my opinion. You can take the organizational chart, flip it on its head. So students are at the top and everyone else is supported. Instead of a chain of command, you have an inverted pyramid of support. Okay. My purpose for coming here and talking to you today is tell you that the failure, personally, I believe, has been from the chain of command, from the top. I really do challenge the Board of Ed and inquiring why this failure has happened and why this procedural error has happened, because I don't believe we are the only family that this has affected. And perhaps the Board of Ed should strongly consider possibly taking any telework away from the superintendent and ensuring that the district is led appropriately. I thank everyone for their time.
Thank you. Anyone else from the public? I seek a motion to close to the public. Page, seconded by Joan Ludum. All in favor?
Aye.
Opposed? Okay. Closed session. It is hereby moved that the Board of Education adjourn into executive session in accordance with the provisions of Section 8 of the Open Public Meetings Act, Chapter 231 PL, for the purpose of discussion and consideration of matters pertaining to the following subject: student matter. The minutes of the executive session will be made available to the public when the need for confidentiality no longer exists. I need a motion to recess to closed session. Oh.
Like a report, there's no, I just wanted to talk
Oh,
about.
the superintendent report?
Yeah,
We didn't have it on.
we didn't have it on here.
No, because we have a meeting in 2 weeks.
Okay, so we'll hold off on.
Okay.
I just want to read this before we go
Sure.
into close. I apologize. I hope everybody had a wonderful holiday break and Happy New Year to you all. I had just two things tonight. I had the opportunity to speak with the mayor today, who is taking, the council is going to be taking the ad hoc flood committee and turning it into an official town committee, borough committee at the committee at the borough level, and they are looking for a representative from the Board of Education to sit on their committee. So if anybody on the board or anybody who works for the school district is interested in representing the school district on this newly formed flood committee, they will be holding a spot for us. They will likely be meeting once a month, probably in the evening.
So if you are interested, please let Dr. Kuchar know about your interest. And just one other thing I wanted to touch on tonight is that it's with great sadness that New Milford has lost one of its finest community members this past week. Unfortunately, Peggy Saslow died on December 26th at 100 years old. In 2021, the board recognized her with the dedication of the tennis courts at the high school, and I had the opportunity to speak directly to her to tell her just how amazing she was. And I'm very grateful that I had that opportunity to celebrate an incredible woman and offer this special honor and recognition befitting of Peggy Saslow. As a woman in a position of leadership, I often look at the women who have come before me, paving a pathway for other women. And one of these special people that I've met in my career and in life, and whom I have adored for many, many reasons, was Peggy. She was an icon, but she didn't know it. And she touched so many people because she was distinguished in all that she did. She was a distinguished educator. She was a retired teacher from this very building. She was a distinguished New Milford Board of Education trustee and New Jersey School Board Member of the Year. She was a distinguished mentor and colleague to other board members. She was a supporter of public education, advocate for necessary changes in educational legislation at the state and national levels, a distinguished supporter of our Holocaust Study Tour program, supporter for meeting the needs of students with disabilities, a diehard fan of our theater and arts programs, a proponent of good nutrition and healthy behavior, an advocate for fitness, and clearly a distinguished role model for our young tennis players, because Peggy was evidence that a combination of good nutrition and exercise will allow you to play tennis well into your 90s. And although I used to tease her that maybe she wouldn't need so many sweaters and blankets if she just ate a good greasy cheeseburger once in a while. But Peggy was recognized formerly also by the New Milford Education Foundation as one of their honorees, and as well as other civic and religious groups have recognized her. But Peggy remained shocked, stunned even, and humbled every single time someone or some group wanted to recognize her for just being her. On a more personal level, I had the pleasure of meeting Peggy in 2010, which is much later than maybe many of you met her so many years ago, but I learned very quickly that she was the kind of woman who would tell it like it is and wasn't afraid to set you straight. And I always found that so refreshing in her. She set the tone for truth-telling, and we all knew we needed to rise to the occasion. Peggy was a voracious reader who shared articles and resources with the Board of Education, with all of us. We'd receive a newspaper clipping with notes from Peggy. She was a true leader, a role model, and a servant to the New Milford public school system and beyond, utilizing her cell phone and her emails for advocacy from the comforts of her own home, even at 99 years old. She was a model for lifelong learning, for community involvement, and she was a leader to all of us. Most importantly, I think that anybody who ever spent any time with Peggy would know that she was a proud mother, grandmother, great-grandmother, a proud Simmons graduate, proud of her Bostonian roots, in total denial of the fact that she still had an accent after all these years. But most importantly, she knew how to make people feel special and how to bring you in as a friend. And I'm so grateful for all that she has done and for just being her true self with me and with all of us. New Milford would not and will not be the same without her. We adored her, and we will miss her.
Thank you.
Okay.
Well said.
So now I seek a motion. Stephanie, seconded by Nicole Dunn, all in favor?
Aye.
Opposed?
Okay. Will we take any action after we come back?
No. So after we go to close, we'll not go back to the public.
So Dan can close it.
Yeah.
Yes.
It's more comfortable.
Yes. Yes. I can escort the family across the hall.
Okay.